Welcome to Veranda IAS. In today's session of Polity Current Affairs, we are going to deal about Attorney General's consent to contempt of courts. So we will see what that is. The learning objective of the day is to explain the AG, that is Attorney General's consent to contempt of courts. That is, when a person is filing a contempt of court case, he has to obtain the prior consent of Attorney General. That is what this is. Then next we are going to examine the Attorney General's consent to contempt of courts in news. Why are we studying this in current affairs? Next one, we are going to analyze the procedure for filing a criminal contempt of court lawsuit against someone. There are two kinds of contempt of courts. One is civil, another one is criminal. Then we are going to explain the Attorney General's consent mandatory for all contempt of court cases. So why Attorney General's consent is required here? Is it possible without the consent of Attorney General to file a contempt of court case? We are going to study that. And at last we are going to explain the situation when the AG refuses to give consent. What happens when the Attorney General refuses to give consent to this petition? So this is the learning objective. We will get into the topic. First, contempt of court. What is contempt of court? Contempt of court is the act of disobedience or disrespect towards the judiciary. Disobedience or disrespect toward a court of law and its officers. So who are all the officers? It may be the judges, it may be the lawyers, it may be the defense side, prosecution side. There will be administrative officers in judiciary, registrar, sub-registrar. So disobedience or showing disrespect towards court or its officers by the conduct that opposes or challenges the court's authority, justice, or in any way if it hampers the dignity of the court, then it amounts to the contempt of court. Contempt can be divided into two categories. One is disrespecting legal officials in the courtroom, and the second one, willfully disobeying a court order. So willfully disobeying a court order, both are different things. One is criminal contempt and another one is civil contempt. Injunctions and other equitable remedies are frequently enforced through contempt proceedings. At the end of these proceedings, the remedial orders or remedial injunctions can be passed by the judiciary to rectify, to punish the person who involved in such contempt. So this is the contempt of court concept. So why it is in news? Why are we studying now? In December 2020, Rajita Taneja, a comic illustrator, that is a cartoonist, has been charged with criminal contempt of court by the Attorney General of India. As I said before, when a private person is approaching the court for a contempt of court petition, the consent of Attorney General is necessary, it is a must. So that is why it is in news. Attorney General has granted consent to the contempt proceedings against Rajita Taneja. So what she did? Rajita Taneja has been accused of embarrassing the judiciary with her tweets and pictures. She has been portraying the judiciary in bad lights. So prima facie it appears that she is doing so with bad intentions. That is why a criminal contempt has been launched by AG, Attorney General, on her. So what is the procedure for filing a criminal contempt? So a motion to commence a criminal contempt procedure may be filed by the Attorney General or Solicitor General. So who is Solicitor General? So Solicitor General is the office created to assist the Attorney General in carrying out his duties. So we have studied Attorney General in polity. If not, you will study in polity. So Article 76 of Indian Constitution, Article 76 of Indian Constitution speaks about Attorney General. So who is Attorney General? Actually, he is the highest ranking law officer of the country. He is the highest law officer. He is not part of the government. He is not a part of executive, or he is not the part of legislature. He is a person who is qualified to be appointed as a judge of the Supreme Court. he will act as the legal advisor of Government of India. That is what Attorney General is. So you will study in detail about Attorney General in constitutional bodies in polity. So Article 76 speaks about Attorney General, and Solicitor General is the office created to assist Attorney General in exercising his duties. So a motion to commence this contempt proceedings may be filed by the Attorney General or Solicitor General in case of Supreme Court, and in case of High Court it will be done by Advocate General. So this Advocate General is the equivalent office created in every states. So this Advocate General, he or she is the highest ranking law officer in a state. So he is the legal advisor of any state government, that is Advocate General. So this contempt proceedings can be only initiated by these persons. If the move is brought by someone other than Attorney General or Advocate General, the permission of Attorney General or the Advocate General in writing is required. This is what consent is. So if at all the consent proceeding needs to be initiated, it has to be done by AG or SG, Solicitor General. In case of state, it is Advocate General. If any private person wishes to initiate this contempt proceeding, then the written consent of this AG or Advocate General is required. That is what we are studying. It should specify the particular act of contempt for which the person charged is accused. So there is a detailed procedure. So that procedure was actually mentioned in Contempt of Court Acts. This act was passed in 1971. A detailed procedure for such contempts were mentioned in this act. So it should specify the particular act of contempt for which the person is accused. The goal of AG's consent is to preserve the court's judicial time, the precious judicial time of the courts, which would otherwise be squandered if a frivolous petition were filed. Some people would be having very light skin towards criticisms. They may not tolerate criticisms. See, reasonable criticisms can be allowed. That is what democracy is. But if someone is offended, even if they are from judiciary or from non-judiciary, if they are offended from genuine criticism, what they will do? They will go for contempt petition. This will actually waste the court's time. That is why before approaching the court with any contempt proceedings, that private person has to go to the Attorney General. They have to submit their accusations. After going through that accusations, if there is any rational, if there is any real willful contempt in that accused person's actions, Attorney General will grant his consent for filing such petitions. If Attorney General refuses to give his consent, that private person will not able to file the contempt proceeding in court. And when the court launches a contempt of court case in suo motu, what is suo motu? By itself. So Article 149 of Indian Constitution. So this you will study in judiciary, particularly Supreme Court chapter, this article. So Article 149 gives the power to Supreme Court to punish for contempt of court, that is to punish any person who is disobeying or disrespecting the Supreme Court. So Article 149 gives the power to punish. So who has the power to punish? The Supreme Court can themselves punish any persons who are disobeying or disrespecting them. So when a court launches contempt of court case in suo motu, that is without any AG's consent, the court by themselves can initiate a proceeding, as it did in the instance of Prashant Bhushan case. The AG's consent is not required. AG's consent is not required. After all, it is judiciary. So they can do anything they want. So they can initiate their own contempt proceedings. They are not going to ask permission from Attorney General. They did so in Prashant Bhushan's case. Prashant Bhushan's tweets, which was actually accusing the Chief Justice and other senior most judges of judiciary, were considered as serious criminal contempts and contempt proceedings were initiated against him. Prashant Bhushan himself is a senior advocate in Supreme Court. So, what happens when Attorney General refuses to give consent? So, if the AG refuses to provide consent, the petition will come to an end there. It will not move forward. So, that is what the rationale of keeping a check AG in between Supreme Court and contempt proceedings. So, if the Attorney General does not find any rationale in that accusation, any rationale in that contempt proceeding, he will not give his consent, he will not give his assent. So, that petition will come to an end there, it will not move forward. The complaint, on the other hand, he has another option. He can plead before the Supreme Court that please take it as a suo motu petition. So, which article we studied that? Article 149. So, the complaint, on other hand, can ask the court to take suo motu action. See, this case is different from this case. This case is one where the private person will be filing direct contempt proceedings in Supreme Court with the consent of AG. But this one, when Attorney General refuses his consent, that person still, if he wants to proceed with any contempt proceedings, he can go to the Supreme Court and ask, please initiate suo motu petition. Start the petition by yourself, start the case by yourself, because AG is not granting consent. So, the complaint, on the other hand, can ask the court to take any suo motu petition. After the consent, if the consent is given by Attorney General, the notice is served personally to the person against whom the court is being asked to start proceedings. So, contempt notice will be served to that person. For what? For asking his explanation. If the court decides not to personally serve the notice, the reasons must be recorded. As per the law, which law? Contempt of Courts Act of 1971. Whenever a proceeding is initiated against any person, a notice has to be served personally to that person. If not, if the court thinks that it is not apt to serve the notice in person, then they can do so. If the court decides not to personally serve the notice, the reasons must be recorded. It has to be recorded. If the court believes that accused contravenor is likely to flee, escape judicial proceedings, it can order the attachment of property of a reasonable value as a collateral. So, if that person skips judicial proceedings or if he escapes from such judicial proceedings, that property of such reasonable value will be forfeited from him. So, they are not going to take away this property. See, this property will be with the custody of judiciary as a collateral if that person skips the proceedings, escapes the proceeding, if he is not obeying the orders of the judiciary. So, what is the case if that person is punished? It may be an amount of fine or it may be a small time of imprisonment. What will happen to this property? This property will be eventually be returned to that person, since this property is not in any way connected to the case. So, this property is attached only as a collateral. Then the alleged contemner may provide an affidavit in support of his defense. That is, he has already served a notice. So, now he has to justify his stand. See, I have a reason, definite reason. So, I have not done this with any malfied intent. This has to be construed as a reasonable, justified criticism. So, he has to do that in his affidavit once the notice is issued, detailing the nature and circumstances of her or his remorse. This is the case of Taneja. The matter must next be heard by at least 2-judge bench. Minimum 2 judges has to be there, which will consider all relevant evidence in order to verify the affidavit and issue necessary orders. That 2-member bench may acquit the person, they may relieve the person, or they may punish the person. They may impose any penalties, fines, or they may impose any minimum sentences, or they may ask any other order, they may issue any other order. It is up to them. So, this is the procedure as per the law. So, what is the procedure? First, it has to be submitted to the AG for consent. Once the consent of AG is obtained, then it has to go to the Supreme Court, and when that case is admitted, a contempt notice has to be issued to the accused person personally. If not personally, then what is the reason it must not be issued personally? That has to be recorded. Then the accused person's reply has to received. He has to file a counter petition affidavit in his defense. A two-judge bench has to inquire this case. They have to hear this case. After considering all circumstances and evidences, affidavits and counter affidavits, they have to decide whether that person is accused of guilty or not. So this is the procedure as mentioned in the Contempt of Court Act of 1971. So students, we are at the end of our session. So in today's session, we have learned about the AG's consent to contempt of courts, Attorney General's consent to contempt of courts in news, why we are studying this in news, procedure for filing a criminal contempt of court against someone. So this is the procedure we studied. AG's consent mandatory for all contempt of court cases. Why it is mandatory? Why it is mandatory? As we saw, it is mandatory to save the judicial time. Next one, situation when the Attorney General refuses to give consent. What happens when Attorney General refuses to give consent? That contempt petition will not move forward. That person, what is the other option he has? He can approach the Supreme Court directly. They can ask the Supreme Court to initiate a suo motu petition. So that is all for today's LU. We will meet in another current affairs session of polity. Until then, stay tuned, keep watching. Thank you very much.